Okay guys, well thanks a lot for coming along. My name's Mark Field. I'm an associate here at Owen Hodge Lawyers, and I'm the family law expert. I run our family law section. I'm an accredited specialist in family law. I've been accredited since 2007, and I've been practicing in family law since about 2001, so about 9 years. I've had a number of reasonably complex cases, as well as just a lot of general day-to-day cases, and I've also given quite a few talks in regard to binding financial agreements. So I've explained those to people, and to some extent I've tried to inform people that you can enter into these agreements. I think there's always a bit of confusion about whether these agreements are binding, and they are. And a lot of people do choose to enter into them. Whether that's something that's appropriate for your circumstances will just depend on the nature of the relationship you have with the person that you're with your partner. But they certainly are available. They are binding. And so yeah, so that's a little bit about me. So I've given talks to a few Rotary groups and Probus groups. Just about financial agreements, and I've also given some seminars about the de facto relationships amendments. I gave one recently that actually, I know William was at that one, just explaining a bit about de facto relationships and the amendments in the Family Law Act. You may or may not be aware that as of the 1st of March last year, if you're in a de facto relationship, you now fall under the Family Law Act, so you pretty much will have the same rights as a married couple. Now that's quite an improvement for de facto couples, because prior to that they had rights, but so that they certainly had an entitlement to property adjustment, but it was limited, and you didn't have advantages such as spousal maintenance and also what we call an adjustment for welfare factors. So if you are the parent who is responsible for caring for children in the long term, under marital law and now under de facto relationship law, you're entitled to an adjustment in your favour. That's something that de facto relationships now have, and you can, I suppose there was a newspaper article initially written, you probably would remember it, it was in the Telegraph, where there was the media basically said that I think it was portrayed that you could lose all your money to your husband's affair partner. I think that was the way it was portrayed in the media. So it was like this big scare campaign that you know, that the mistress was going to take all your assets, sort of thing, which was obviously a typical sort of misconstrued by the media. But that was all in relation to the de facto relationship amendments. And what that was foreseeing is that you were going to have these relationships going to court, and you might have a husband and a wife, and you might also have a husband and a girlfriend as well. If they've been in a relationship for long enough, they have similar rights, so you could have multi-parties in the family court. So I think that's what they were sort of alluding to. But anyway, what I'll do, this talk is basically, it's sort of like a step-by-step process going from separation through to divorce. I've kept it fairly general, and I'm happy to answer questions on any particular issue, but what I'm sort of hoping to do with this talk is just help people navigate that process when they decide to separate to the point of where they get divorced. Because there's a few things that people always get concerned about, and that's what I've tried to pick up in this talk. So anyway, okay, well, let's move on. We'll start moving on. Okay, so this is a little flow chart that my assistant put together, and it sort of shows the sort of steps that you go through. If you follow down the middle, that's the sort of thing that's in regard to parenting issues. So you've got your date of separation. Invariably, all parties go to counselling or mediation. A lot of people don't like to go to counselling because they think they can solve their problems themselves. I think they're the biggest fools out, because I think that not only does counselling help you to potentially resolve your relationship, but it also helps people to deal with the hurt that they've experienced as a result of the breakdown, and it makes it so much more easier for them to then go through and resolve everything. I find a lot of clients, they don't have counselling, and then they spend all their family law proceedings basically getting so upset and trying to deal with all the hurt, and unfortunately it's costing them a lot of money that way because they're not thinking very rationally. But counselling mediation is certainly something that most people do. Certainly mediation, the family court encourages people to go to mediation and try and resolve parenting issues and property issues. Following down the middle, if you are able to resolve your parenting issues, you can enter into consent orders, you can enter into child support agreements, which deal with child support payments, and you can also enter into parenting plans. And then if you disagree, then you've got parenting orders, which is when you go to court. The left-hand side is just a sort of talks about your property issues. So if you've got an agreement on how to apportion your property, you can enter into consent orders or a binding financial agreement, which is the same as a prenuptial agreement, but it's effectively a sort of agreement after separation. And then once again, if you disagree, you go to court and you get some court orders. Now, on the right-hand side, it's much the same, but it talks about maintenance agreements as well, and that's really where there's an issue of spousal maintenance. So we talk about this in a bit more detail in the following slides. This also talks about divorce. Everybody's concerned about when you can get a divorce. You have to be separated for no less than 12 months, and then once you satisfy that criteria, then you file an application for divorce, which you can actually do yourself. It's not that difficult. You can fill one out off the family court website, and I think the filing fee is $453 if I remember correctly. And then what you do is you then lodge the matter in court, and if there's children under the age of 18 years, the court does require some explanation that there's appropriate arrangements for the children. So you might need to go to court for one particular date where you just sort of tell the registrar, yes, the children are being cared for and they're being provided for. And once the court's satisfied of that, they then make the divorce order, and the divorce order becomes effective 1 month after the day of that court date.